Every judicial system has its flaws and mistakes. Every detective is a blunder, yet the following cases cannot be called mere mistakes and have to be classified as miscarriages of justice. The Showbiz murder is the much talked about homicide on record producer Bart van der Laar that happened on the 10th of November 1981. His secretary found him in a pool of blood on his kitchen floor. 2 shots were fired. The first hit him in the head and would prove fatal. The second misfired and did not cause any major injury. A veritable army of 100 detectives was assigned to the case, and they had hundreds of artists come in to give a statement. Yet the case would soon stagnate and appear on Opsporing Verzocht, a program that gives details on police cases and asks the public to provide tips. With an added bounty of 20,000 guilders, pulled together by a group of artists. After the broadcast, 22-year-old nurse Martien Hunnick would call the police and profess he had been to the victim's house as a prostitute and knew more about the case. During the first interrogation, he would confess to murder and stick to his story until the official confession, yet withdraw it soon after. He would be sentenced to 2 years in prison and detention under hospital order. He would end up spending more than 8 years in prison and clinics, yet always insisted his innocence. After many years, he would be acquitted in June 2016. He could not have committed the murder as he was at work when van der Laar was killed. How could the police have missed this easily verifiable evidence? They didn't, but it was ignored in favor of a quick conviction in a case with few leads. In his statement he said, "I left work at 9:40 and took a taxi to his place of residence. I visited a friend to borrow a gun, which was wrapped in a shirt. Went to the victim's house and shot him twice." According to autopsy, however, the victim was killed before 9 a.m., already making it impossible for him to have committed the murder. Further, his dad picked him up from work, who, together with employees from his workplace, confirmed he left at 10. But this was close enough, and the time of death would be ignored. They went to question the girlfriend of his friend, who confirmed he did stop by to borrow a shirt one day, but she didn't know the date or time, making the testimony worthless for the investigation. The officer didn't think so, though. They asked her if he could have come by after 9:30, to which she replied, possibly, but no later than 11 a.m., making it possible he borrowed the gun that day. The fact she didn't know the date mattered not to the police. His own confession was also manipulated by the detectives. An important example of this concerns the murder weapon. The weapon was a revolver which doesn't eject bullet casings. When asked if he had considered if he left casings on the scene, he said no, meaning he probably doesn't know what weapon was used. Yet they pressed on to ask were they maybe left in the weapon, which is a closed question and steering of the suspect. Knowing all this, why did he call in the first place? As a cry for attention, and he wanted the 20,000 guilder bounty. On the 13th of October 1995, the 25-year-old Jim was sentenced to 12 years in prison for the murder of his mother 4 years prior. He had used a small crossbow to shoot a big brand ballpoint pen into her eye, killing her on impact. Outside of having the opportunity, the only evidence against him was having been overheard discussing the perfect murder, shooting someone with a pen using a crossbow, and the testimony of his therapist, to whom he had said, "It's my fault my mom is dead," which should not have been evidence, as things said in a therapy setting are not applicable to be used in a judicial setting. Many experts disagreed with this conviction and declared it's impossible to shoot a pen that deep into the skull with the limited power of a small crossbow, and instead proposed the fall theory, that she had fallen on the pen. After multiple tests on human heads, it was found possible, but it would not end up the same way as it was found in the victim. Because of these newfound facts, he would be exonerated on the 5th of April 1996, and this case would become known as the ball pen affair. In actuality, the police knew the fall theory, but they left it out of the report, as they chose to treat it as a murder case. Of even more interest is on what basis he was arrested. When they used only part of the statement by his therapist, he was let go, but when they used the entire statement the second time, he was kept. Using the same evidence twice is illegal and basis for a mistrial, which is why it was not included in the report. Jim's father filed for the right to access the reports, which was granted, yet the documents were destroyed by mistake the day before he was supposed to receive them, something which happens an awful lot in the Kingdom of the Netherlands, especially in the Department of Defense, where every single important case file is either destroyed or lost. The 23-year-old Crystal was found dead in her grandmother's house on the 9th of January 1994. The main pieces of evidence were a drop of semen on the victim's leg and two hairs that didn't belong to the victim. During the investigation, many residents of Putte were heard, including four men who were driving around in a Mercedes in the vicinity of the crime scene. Other witnesses had reported seeing the brand of car at the time of the murder, and these men would become the prime suspects. They would be interrogated and given details about the case, including each other's statements. Two of the suspects accused the other two of committing the murder. They had dropped them off and later walked to the house, where they saw the two men strangle, rape, and then kill the young woman, after which they left the premises together. None of the DNA traces were a match with the two suspects, but this would be ignored by proposing the drag theory, where the semen would have been from previous sexual contact. In October 1995, they would be sentenced to 10 years in prison, and the two accomplices would go free. The expert that had given the drag theory as a theoretical possibility would withdraw a statement after he saw how the police had used it. Seeing as there was no direct evidence other than the testimonies of their accomplices, they would be exonerated when the case was reopened in April 2002, after serving the entire sentence, and received 1.8 million euros in compensation. 15 years after the murder, a new suspect was found after a DNA match, the 33-year-old Ronald P. He would be convicted to 15 years and 6 months and to another 4.5 years for manslaughter of another victim. On the 22nd of June 2000, an 11-year-old boy ran out of the Beatrix Park in Schiedam. He had a shoe tied around his neck and was bleeding from a stab wound. Clinging to a passersby, he said, he and a friend were forced into the shrubbery at knife point and made to undress, after which he was assaulted and played dead, and the 10-year-old Nienke was sexually abused and killed. This horrifying case would be known as the Schiedammer Park murder. On the 5th of September, the man who called emergency services Case B was arrested as the prime suspect. After it was discovered he had regularly asked 10-year-old boys to satisfy him orally in exchange for 25 to 50 guilders. The evidence against him was, he was present in the park at the time of the crime. He was seen at the crime scene a short while before. His bicycle resembled the one seen by witnesses close to the crime scene, and he had a sexual preference for children. This, together with his confession after days of harsh interrogations where he was pressured immensely, would lead to his conviction. In late May 2001, he would be sentenced to 18 years in prison and detention under hospital order. Yet there was far more proof against him being guilty. He did not look like the description. It proved impossible to fit the needed actions into the timescale. There were no DNA traces found, even though he had abused both of them with his bare hands. This after the biggest DNA investigation ever held in the Netherlands. The confession Case gave was also steered. An example of this: the detectives asked if there was something on the head of the deceased victim, implying there was something. They continued, what was it then? A shirt maybe? Was it light or dark colored? When he replied light, they said, you know very well what the color of the shirt was. This way of steering was used continuously until he gave them the exact statement they wanted. He complied with this because he was so sick of the continued harsh interrogations. He would eventually be exonerated in 2006 and receive 600,000 euros in compensation. On the 17th of September 2004, a man was arrested for trying to assault one woman and trying to rape another, yet it would still be a surprise when he would suddenly confess to the park murder, before withdrawing it a day later. Yet DNA tests already showed he was a match with the traces found in the case. And on the 22nd of November 2005, Wick H. would be convicted to 18 years in prison and detention under hospital order. Because the police knew there was never any direct evidence against Case, it would immediately turn into a scandal if Wick was found to be the true culprit. So one of the prosecutors tried to cover up the confession to spare the judicial system from having yet another failure revealed, to no avail as it went public shortly after. The NFI already knew there was DNA from an unknown third party, and that traces from different origins matched each other, meaning it was a single individual, meaning if it wasn't the case, he wasn't the culprit. The police were blamed for this grave miscarriage of justice, in particular obscuring the DNA results. They searched for evidence to convict the suspect instead of searching for a suspect to match the evidence. The other victim would be designated a suspect, and even though he was only 11, would be intimidated by having two adult detectives interrogate him alone. But he would also blame him for not helping Ninka. Minister of Justice Dunner would have to answer for his ministry's failure in Parliament when it was decided a special commission would be created to investigate the shortcomings. After a baby unexpectedly died in the Juliana Child Hospital in Den Haag, a report was made to the police on the 17th of September 2001. The death might have been unnatural, as one of the nurses, Lucia de Berg, was present at unexpected deaths remarkably often. In the year prior, 9 of these unexpected deaths and resuscitation incidents had taken place. Lucia had been present for all of these. Even more of these incidents were found in the previous hospital she worked at, bringing the number to 30. Though most of these cases could actually be explained and would not be included in the charges against her, colleagues were questioned and all declared she was a good and pleasant co-worker, and she herself chose to remain silent during interrogations. In the early 70s, her family lived in Canada, where their house would one day burn down. It was caused by a short circuit, yet with the newfound evidence in the Netherlands, she was suddenly suspected of arson, and Dutch detectives would travel to Canada to investigate her past. According to some nitwit, this would fit into her profile as a serial killer, but there is no proof she was one in the first place, nor does arson fit anyway. This wouldn't stop the police from portraying her as one to the judges, however. The police arrested her while she was at her grandpa's deathbed. She had been caring for him for a long time when police charged in and took her away. While she was being taken, she said, "Why can't I finish this?" which would be used as evidence she was planning to kill him as well. No indication of this was ever found. In June 2004, she was convicted to life in prison plus detention under hospital order, the harshest verdict ever in the country, and not just harsh, impossible in fact. The law does not permit contradictory sentences, and it was amended to just life in prison. This conviction upon the basis of a probability calculation, the chance of her being present at so many events was 1 in 342 million. Only 2 of the 7 murders and 3 attempted murders she was convicted for were proven, but chain evidence was used, meaning having 2 murders proven meant all of them were regarded as proven. She had poisoned them with digoxin, yet this was disproven in a report published just after the ruling. They had used the wrong method, which did not account for the body's own quantities, and this produced an erroneous result. Yet this would not lead to a retrial. She would be exonerated after 6.5 years on the 14th of April 2010. Reasoning were the facts, no murders were proven. In many of the cases it was never deduced that she could administer the poison, and the probability was calculated incorrectly, in actuality being as low as 1 in 9. This entire case was a clear example of tunnel vision. It was assumed murders took place, despite a lack of evidence, so a culprit was chosen among the nurses. She would receive an unknown amount in compensation. These were the most famous of the cases, and exemplify the atrocities that can occur when the police suffer from tunnel vision and work towards a desired conclusion instead of searching for a conclusion to match the facts. This is the Lore Sanctum. Have a nice day.